When is a deal a deal? It's not uncommon for a client to come into my office and express buyer's remorse, regret, or simply that sinking feeling experienced a few hours or days after settlement. The client's changed his or her mind. Typically, the client is seeking a second opinion, coming to my office having lost confidence in his or her lawyer. And, most lawyers want to make their clients happy. However, it is inevitable that sometimes you cannot. This begs the question, when is a deal a deal? The first step in the analysis is determining the existence of a contract. Did the parties manifest an intent to enter into a deal? What do I mean by that? Was there an offer made during settlement negotiations, typically in divorce context, in the case of a mediated settlement? Was the offer accepted? And was there adequate consideration? Was something bargained for or given in exchange for the offer? Typically in Michigan, settlements in divorce cases or custody cases arrive in different ways, such as a settlement that's been placed on the record where the parties are placed under oath and a record is made under contractual terms, and other times at mediation. Now, when settlements are placed on the record, there's a case called Kalo versus Kalo that says a stipulated settlement was placed on the record and plaintiff subsequently became dissatisfied with the terms of the property settlement. The court determined it is well-settled law that courts are bound to uphold property settlements reached through negotiations and agreement by the parties in a divorce action absent the three following things: fraud, duress, or mutual mistake. Now, fraud is a material misrepresentation of a fact. What is duress? Almost like I was forced to do it. Maybe the ultimate form of duress is when somebody places a gun, I guess, if you're being robbed in your head. That certainly is not a voluntary act. Or a mutual mistake. We both thought we were dealing with this number and it actually was something else. Realistically speaking, though, it is very difficult, if not impossible, to demonstrate all three or one of these three exceptions to the rule, unless it's blatantly obvious. Maybe I had one case where an individual lacked the legal capacity to enter into a deal. We had a neuropsychological examination saying that they suffered from a psychiatric disorder that prevented them from having capacity and were able to unring the bell. Which begs the question, why is it so important to hire a good lawyer that you're comfortable with in the first place, and why it's also important to understand that when you enter into a property settlement, in the context of a divorce, it's final and non-modifiable. Now, there's other cases where mediation settlement was recorded. That is, it's not uncommon when we mediate a divorce case to take a recording and record the settlement. That is, the mediator or one of the party's lawyers will ask questions and answers. And in Michigan, there's something called the Statute of Frauds. The Statute of Frauds requires certain contracts to be in writing to be enforceable. For example, contracts that cannot be completed in a year, contracts for real estate, and so forth. And this appears at first glance to be a barrier to the enforcement of an oral agreement placed on the record regarding real estate. For example, mom's going to get the home, or dad is going to get the vacation home, whatever the case may be, or husband and wife. And unfortunately, Michigan Court Rule 3.216H7, that's unfortunate to those individuals that want to assert the statute of frauds as a defense, that the court rule provides MCR, Michigan Court Rule, once again, 3.216H as in hotel 7, provides that the terms of settlement reached as a result of mediation is binding if 1, reduced to a signed writing, or 2, acknowledged by the parties in an audio and video recording. So what is the key learning here? Once again, the key learning is that a settlement that is placed on the record as it relates to property is final, binding, and not modifiable, absent a showing of fraud, duress, mutual mistake, or in the example that I just provided a few moments ago, the inability to enter into a contract because of lack of capacity. The key learning, once again, is it's important to have good representation prior to entering into a deal, and certainly make certain you understand the obligations and rights that you have under the deal that you've reached. I'm Daniel Finling with Finling Law and thedivorceguy.com.